Good afternoon and welcome to the first installment of the Adult Task Force webinar series. My name is Amethyst Johnson and I am the Manager of Information and Referral Services here at the TAA. Today we'll be addressing the topics of workplace accommodations and disability rights. Here with me to expand upon the subject are two experts from the organization Disability Rights Wisconsin, Ellie Jarvie, MSW, LCSW, and attorney Steven Corfman. Ellie is an adult with Tourette Syndrome. She is the chair of our TAA Wisconsin chapter and works as an advocacy specialist for Disability Rights Wisconsin. Ellie found that educating others about Tourette Syndrome was a key accommodation for her success in school and in the workplace. She has worked with youth and adults with a variety of disabilities, including intensive experience in community mental health programs. Steven is a Wisconsin licensed attorney who focuses on disability discrimination prevention. He decided to pursue discrimination law after finding a deep satisfaction in civil rights related volunteer work. He has published on local anti-discrimination ordinances, and his law school training included work at the U.S. Justice Department's Civil Rights Division and the Southern Poverty Law Center. He practiced disability law at Legal Action of Wisconsin before joining the Disability Rights Wisconsin. If you have any questions during the webinar, there will be a Q&A section at the end, and the webinar will be available on our YouTube page following this broadcast. I'm now going to turn it over to Ellie Jarvie. Ellie?
Good afternoon, everyone. We're delighted to present today for the first of the TAA Adult Task Force webinars. So we wanted to start with a brief outline on what we'd be talking about. First of all, we'll hit our vision, dignity without a ceiling. Then we'll talk about the threshold when the Americans with Disability Act applies. Then we'll move on to getting the job, application and interview. Moving on to starting the job, offer and onboarding. Then making the job a career, retention, satisfaction and achievement. And finally, if something goes wrong, processes to protect your rights.
So one of the things that comes up, because we'll be talking about the law a lot today, is oftentimes when people talk about the law, there's a focus on compliance. What's the minimum that I need to do in order to not be in violation of the law? But the approach that we really want to take today is looking at the spirit of the law. What was the Americans with Disability Act, the ADA, designed to accomplish? Because so often that temptation to look at compliance means that the minimum standards for what the law requires become the maximum expectations that we might hold for an employer or society in general. And so we really want to encourage a view of, yes, we started compliance as the minimum, but that's not the maximum expectations for what a workplace can look like and feel like.
And I think as a person who's used accommodation, that's a really important concept, because when you go in knowing your rights and then have a vision on, I want to create an environment where I can succeed and do my best and have that positive expectations, that reaps amazing benefits for you and for your workplace.
So then into some details about what the law actually requires. There's a few things that are kind of the basic starting point for when the ADA would apply. The first is that it protects people who have disabilities, and that can be actually having a disability in terms of something that's ongoing, but it can also be something that whether an individual does not have a particular condition, but the employer believes that the person does, just has some suspicion of some kind. That type of discrimination based on the employer's belief is also protected against. And then the other category that's protected against is if a person previously had a disability, but through treatment or the course of how symptoms work in a particular issue, that diagnosis is no longer influencing a person's life in a way that rises to the level of being categorized as a disability. That history of or record of is also protected. The major piece though that we'll talk about today is when a person's symptoms do rise to the level of substantially limiting one or more major life activities. And then the statute that's cited there gives some examples of what counts as a major life activity. So we're talking about things like concentrating, communicating, speaking. Those were all things that if there was a substantial limitation in one of those activities, that would qualify as a disability under the ADA. The other thing that I think is important to note about kind of that starting point, whether the ADA applies, is that it only applies to certain types of employers, and certain types of employees. So that when the ADA was passed, there was a real concern about not harming businesses by creating this compliance requirement when businesses were small and lacked resources to understand the law and really put efforts into doing things that follow it. And so based on that, Congress actually carved out any employer that was fewer than 15 people. But if your employer has 15 or more people, and it's not just a seasonal thing, it's not just 15 people for the month of December because of a holiday rush, but 15 people who are there for kind of an extended period of time, 20 or more weeks out of the year, then that employer would meet the size requirement. The other kind of threshold component for when protections kick in is that you have to be an employee or an applicant to become an employee. And so there's a distinction in the law between an employee and an independent contractor, where an independent contractor might be doing a particular job or hired to complete a particular thing, but not really be employed by the organization. And so the ADA applies to employees, but not to independent contractors. What's important to note there is that sometimes employers will describe somebody as an independent contractor when that person doesn't actually meet the legal definition of what an independent contractor is. Courts look at how employers and employees describe the relationship, but that description isn't conclusive. So if you think you might not have protections because of your categorization, I would recommend talking to an attorney who's licensed in your state to understand whether you actually do meet that criteria or not. And then the third thing that is important to talk about in terms of just the threshold for whether the ADA applies is the types of discrimination that it applies to. And the ADA describes discrimination quite broadly. Oftentimes people will think of discrimination as being singled out for different types of treatment. That's called disparate treatment, and that is protected by the ADA, protected against by the ADA. But there's also two other categories of discrimination that are prohibited by the ADA. The first is a failure to reasonably accommodate. And so that's what we'll be going into more depth into today, about if there's something that you need in order to succeed on the job, in order to perform the essential functions of the job, that these changes, modifications to how, to what resources are available or how policy is applied in your situation, if there's modifications to those things that can enable you to succeed, generally the employer would be required to do them unless there's an undue financial hardship or it creates some type of a very serious direct threat to health and safety. The other category of discrimination that the ADA protects against is what's called disparate impact, which is when an individual person isn't being singled out, but there's a policy that as a whole has the effect of excluding a certain group of people. So that's going to be probably less of a focus for today. The other thing that I want to note is that these limitations, like the size limit, that's for the federal protection, the Americans with Disabilities Act, but there's state laws differ. For example, here in Wisconsin, there's not that size limit. An employer just has to have at least one employee to get protection under the state law. So if you're at an employer where you might not qualify for ADA protection, it's worth talking with a local attorney to get advice about whether you might qualify or your employer might qualify for state-specific protections. So then we'll get into kind of more of the actual substance of going through the job application process. The first thing that's really important for you to know is at the application stage, there's limits on what employers are allowed to ask. They can't ask questions that are designed to elicit disability-related information. That's called a prohibited disability-related inquiry. There are some things that there are some exceptions to that general rule. The first is an employer can ask if you will need accommodations during the application process. The employer can also ask in situations where the disability is apparent and obvious, the employer can ask if you will need accommodations on the job. If you say no because you won't need them, then the employer can't probe further. They can't say, well, do you really not need them? That inquiry has to stop as soon as you say no, you won't need accommodations. If you will need accommodations and say so in response to that question, then the employer can ask for what types of accommodations you need and could ask you to demonstrate how you would do the work with those accommodations. So those are kind of some of the important pieces about limitations on employers at the application stage. The other thing is that you can get accommodations for the application process itself. But before we go into that request process, I think Ellie had some information to share on kind of how to talk about your disability.
So I think at any point when you're talking about disclosures, it's really helpful to do some thought ahead of time about how living with Tourette and associated conditions has been a strength for you. For example, I had significant vocal tics from the time I was in my early teens through my mid-30s. Now, because of that, I got very good at standing up and explaining Tourette in public and dealing with public questions. So what some people might see as a deficit, I turned to a strength. Same way with working with systems, dealing with bureaucracies. That's something I do now in my work every day at Disability Rights Wisconsin. And a lot of that I certainly learned through other work positions, but also through my personal lived experience of living with Tourette and having people telling me I couldn't do something or I needed to do something a certain way. I had to get adept at learning what were the ways around that, how I could make the system work for me, and how I could respect the rules of the system. So that's a quick example of how you might turn in what's a deficit into a strength in your workplace.
Right. And so the next step, kind of, if you do need accommodations during the actual application or interview process, is to go ahead and request those. There will often be a contact person for requesting accommodation that's someone other than the hiring manager, for example, an HR person who's identified as a contact. It might be the actual manager who's doing the hiring, but the job application or job description or listing itself should generally identify who that contact is. And if not, you can reach out to, you can see if the HR contact person is listed on the organization's website. In general, there's going to be the accommodations that are requested during the application and interview stage are for the application and interview itself, rather than requesting accommodations that you would need on the job at that earlier stage. So there's some, and as an example of how the application could be accommodated, sometimes employers will have people fill out forms during the interview itself. If you arrive and are waiting for a few minutes, I know when I applied to Disability Rights Wisconsin, there was some information about our background that we were asked to fill out on the spot. And so one of the things that often can accompany Tourette is dysgraphia, where there's some difficulty with handwriting. So one thing that you could do to accommodate dysgraphia would be if the employer makes known that there's going to be something handwritten as part of the application process, you could ask to receive those forms in advance. That way you could type them out, or you have more time to make your handwriting legible, where it might not be possible on the spot in that kind of rushed situation. And so that's one example. The other type of accommodation that can be done at the interview and application process is sometimes employers will have some kind of testing. So for example, in a number of legal jobs that I've applied for, there was writing tasks that were part of the application itself because the employers wanted to see whether the applicants could write coherently. And so in that type of situation, if I had if there were symptoms that impacted concentration or the ability to do something in a very condensed span of time, you could ask for additional time as part of the accommodation. The one limitation on that is that employers wouldn't be required to accommodate something where the test itself is designed to test that ability. So for example, if there was a clerical task that involved a lot of typing and very high volumes of information, and you had to type very quickly, and there was a typing speed test, you probably couldn't ask for additional time on the typing speed test. But as long as the thing that is being tested is different than the thing you're asking for an accommodation for, then the employer should be able to provide an accommodation on that. At the stage, once you have an offer or a conditional offer, then the employer is actually much more free to ask questions than either earlier, pre-offer, or even when you're on the job. You can ask kind of a broad range of questions. And what I mean by conditional offer is a lot of employers will say, we're going to, we're interested in hiring you, but first we need you to complete this physical or this drug test, this drug screen. So those are the types of things where there's an offer in hand, but there's some additional step that needs to be completed, or for example, a security clearance and needs to be completed before the job is yours. So that's what I mean by conditional offer, where there's those kind of things remaining. But what's important is about what employers can ask at this stage is they can't ask something different of a person who they believe has a disability or who has a disability than they would ask to somebody else. So for example, a police department where there's high levels of physical demand on a field police officer position might have a physical examination as part of, passing a physical examination might be part of a conditional offer. As long as it's not required because they suspect you have a disability and is required for everyone who's being given offers for that particular position, that would probably be permissible. So that's kind of a general distinction between what disclosures are an employer can require. The other thing that I didn't mention earlier, but that I think is important, is what the limitations on what an employer can require aren't limitations on what you're allowed to share. So if you really think that it's important for the employer to know about information in advance, either because that's part of the strengths that you're communicating, or because you want to understand the employer's reaction to it to decide whether it's a place that you want to work. You're welcome and free to share information, even information that the employer wouldn't be allowed to ask about without your initiating the disclosure. The other thing that is important at this kind of pre-start stage, once you have an offer in hand, is you can actually start going through the accommodation process here as well. So if they're not just for the application, accommodations that might change the application process, but if you're looking for accommodations for on the job, then this can be a good place to start for things that you know about in advance. And so I think Ellie's got some information about some accommodation ideas.
Sure, just some real life examples. One accommodation I've used in most settings has been a laptop. Now that's a nice one because it's much more common than it used to be, so it doesn't stick out. Any kind of specialized tech that you might need, some people use type to text or a smart pen. Sometimes a separate area, whether that's an office where you can close the door or a place that you can go to release symptoms. Flexibility and schedule works there too, also not just for symptom expression, but let's say you're starting a new med that might make you kind of tired. Another big one that I've used in most all my workplace settings is the ability to explain Tourette. That's especially been important when I've had supervisory positions where I've been dealing with a lot of other new agencies, new contracts. Doesn't have to be a long time, just that 30-second elevator speech so people know what's going on. I can explain what's happening and we keep those relationships strong.
Right. And so the overall thrust of what an accommodation would be and what those examples that Ellie just gave kind of fall into is some change to either the resources that are available to you on the job or a policy of the organization or some practice, how they do their regular business for most people. It would be some change in that. So if an employer says, well, that's not how we do it, which sometimes employers will respond when you're asking for something to be different, well, we don't do that. Well, the accommodation process says, even if you don't do that in other situations, because of the need to provide disability-related supports required under the ADA, I'm asking you to do it in this case. And the general thrust of the types of things that would be accommodations are focused on enabling you to perform essential functions of the job. So the federal law, the Americans with Disabilities Act, makes a distinction between essential functions and marginal functions, where essential functions are the core reason why the job exists. And oftentimes job descriptions will say these are the essential functions of the job and these are some additional functions. But those descriptions, they're taken into account by courts when evaluating whether a particular function is an essential function, but they're not the final word about whether something is essential. So if there's something that other people in that role don't really do, but they're saying it's an essential function for you, there could potentially be some room to challenge whether what the employer is claiming is an essential function really is. And that comes up because there are some times where there's a task that no matter what accommodations are available, the person just wouldn't be able to do that particular task. And if that task that you cannot do without, even with accommodation, if accommodation won't enable you to perform all the essential functions of the job, then that passes the limits of protections under the ADA. So that's when employers could demote you or terminate the position if you're not able to perform those functions. But if something is a marginal function where, yes, it's part of the job, but it's not really the core to why the job exists, then even if no matter the accommodation, you couldn't do that marginal task, the employer couldn't use that as a basis for some type of negative action. So an example of that the Equal Employment Opportunity Commission uses in some of their literature is if there's someone who's a file clerk and also has a role of being the backup for answering the phone if whoever regularly answers the phone isn't available. And it might be that the person does answer the phone sometimes, but if it's the backup to somebody else and it's not really that frequent, if you suddenly have a difficulty that makes it hard to complete the task of answering the phone, that wouldn't give the employer an excuse to treat you in some negative way because it's not really essential to what the job was designed for. So those are some things. The other thing, to build on Ellie's example of some accommodation ideas, is we want to alert you to a resource called the Job Accommodation Network, and the website for the Job Accommodation Network is askjan, askjan.org, and they have just this library of wonderful accommodation ideas down to the level of very specific information. So for example, one of their accommodation ideas for Tourette syndrome is if there's vocal tics that other employees might view as a distraction, there's equipment that can be attached to cubicle walls that dampens the spread of noise. So not only does the Job Accommodation Network identify that specific idea, but they also actually will go into the level of detail of, and here's some suppliers where you can get those types of cubicle wall attachments. So that's one particular example, but it's a really good resource for going to the level of detail, not just of brainstorming, but how to actually implement something in practice.
So you'll see that resource in our resources tab, and I encourage you not to look only under Tourette syndrome, but you can look under issues you have, and think about associated conditions too. The other nice thing about the Job Accommodation Network is a lot of HR professionals are already familiar with it, and they see it as a credible and neutral source.
So then we go into you've completed the interview, you've landed the dream job, you passed all the pre-offer negotiations, and you're there, first day on the job, or you've been on the job for a while. And there's some things that you might find out on the job that you didn't know in advance. So for example, one of the accommodation ideas that Ellie talked about was with regards to particular physical spaces, somewhere to go, to release tics, or having an office where you have a closable door rather than being placed in a cubicle where noise might spread more easily. So some of that you could request at the before starting, after you have the offer in hand, you might not be aware of. They might not have decided where your desk is going to be if it's a desk job. And so this is the type of the importance of accommodations on the job versus before starting is that you might have additional information that you didn't have about what barriers might be in place or what accommodations might be workable. So it's important as the job develops to stay abreast of where there's any difficulties arising, what changes would make the job performance higher or the job itself more satisfying that are related to the disability. A couple of common ones, if symptoms are exacerbated, there can be a need for a more intensive treatment that pulls someone away from work for a while. So leave, unpaid leave is a fairly common example of type of accommodation that's requested. There's some limitations to when a leave would be considered reasonable under the ADA. In general, employers are not required to provide accommodations that would create an undue hardship, meaning the expense would just be really excessive. And that's going to be specific to each employer. What's going to be a hardship for a company with 10,000 employees is going to be different than what's a hardship for for the corner grocery store that's got 15 employees. So just the financial information about the employer can influence what's reasonable. But in general, one major thing that happens with leave that will generally make leave requests in certain situations unreasonable is if you don't know how long the leave is going to last. Employers will generally be able to show that there's a hardship that creates an exception or defense for them if the leave is for an indefinite period of time or a really lengthy period of time. If it's a matter of weeks or months, then and the length is known, then leave requests can generally be reasonable. You might also have protections related to leave under the Family and Medical Leave Act or a state equivalent of the Family and Medical Leave Act. Here in Wisconsin, there's a Wisconsin equivalent. But there's requirements for meeting those, that, the leave laws that are separate from qualifying for ADA. Another common one that employers will often be able to show is unreasonable, but can be reasonable in certain circumstances, is working remotely. So for example, if tics intensify to a point where the employer views that it's really not workable in the type of office setting that there is, or the type of setting, oftentimes one way to resolve that would be working remotely. I actually have a client right now who's doing exactly that. That's also going to be really employer to employer and based on the specific situation, but also even position to position. So for example, someone who's in a supervisory role, there might be more demands on the person being present, more tasks that really need the person there, for example, in order to observe what the people they're supervising are doing. And in some cases I've seen collaboration, someone who's doing a lot of teamwork, employers might be able to show that not being immediately by their team members in a way that facilitates more spontaneous conversation as opposed to planned conversation, that can be seen as creating a hardship that makes something unreasonable. But it's going to be specific to the individual position and the employer, and oftentimes working remotely can be reasonable. But also, even if it's not required by the law because of being deemed reasonable in a particular position, you can still ask for it. If the employer is willing to do it, even if they're not required to do it, that can really be something that employers who are intending to be supportive are willing to do. And there's other types of accommodation requests like equipment and those types of things that are also fairly common. Another thing that really impacts job satisfaction is the culture of the organization, whether or not you feel like you're going to work as a peer or if you're being singled out and treated differently. And unfortunately, this is an area of law where there's much weaker protections than people assume related to harassment. The Americans with Disabilities Act does protect against harassment in the workplace, which is also can be described as a hostile work environment. But the limitations aren't the types of situations that many of us would view as undignified or unfair. The EEOC materials on this in courts will specifically identify anything that is just teasing, and they use the word teasing, as below the threshold of what's protected. In general, in order to be protected against harassment is going to have to be either severe or pervasive. So if it's one time or a couple times, it's got to be very serious. And if it's a less serious but is more common or constant, then something could rise to a level of being pervasive. The other component to harassment is that you have to be able to show that it was imputed to the employer, that it wasn't. So generally that's going to be done by showing there was a supervisor knowledge of it. If there wasn't a supervisor there, told the supervisor about it and they failed to do anything. So if it's coworkers who aren't at a supervisor level and the supervisor and no one in management knew about it, then the employer is generally going to be able to show, well, some coworkers did it, but the organization, us as the employer, we're not the ones that did it. And so it'll be really important to escalate it. It's also important to escalate it if it's happening and management doesn't know about it, just so it can get fixed. Outside of the legal protections, employers might do something about it. But even if you think your employer's not going to, if your supervisor, you just doubt they're gonna follow up, it's still important to raise it to your supervisor and escalate it internally, because otherwise those protections might not be available. I'm going to go into two examples because I think examples show more information about what harassment really involves. The first is, I'll do an example where it didn't meet the criteria in a very frustrating way, and then an example where it did meet the criteria. So one that the employee was not able to show harassment protected against under the ADA for was a case of an individual who had multiple sclerosis. He walked with a cane. On at least one occasion at work, the multiple sclerosis resulted in him having an unintended bowel movement, an accident, and some coworkers on 2 occasions took his cane and hid it in the warehouse that they were working in twice. And after, the next day after an unintended bowel movement, a coworker left in his work area a children's book about potty training. So these are just awful experiences. And in the case of actually taking and moving the cane, it rose above the level of words or communication and actually was this physical interference. And the court in that case said, because he was able to brush it off and it didn't interfere with his work, and the employer's supervisor didn't know about it, it didn't rise to the level of being harassment under the law. So that's an awful case where there was a gap between what's fair and right and just and what the law protections, what the legal protections provide. Now another case, it happened out of Costco, where there was an individual with Tourette Syndrome who had some vocal tics, and as part of his vocal tics, he would reach down to the floor to touch the floor at times that he was making vocalizations. Because of the way that he was touching the floor, reminded coworkers of a particular way of standing in football. The coworkers, were constantly teasing him in direct view of supervisors with a football phrase. Basically, most times that he was having tics and doing that, coworkers or supervisors were responding with this demeaning response. And what made that at least qualify for to be counted as severe and pervasive and imputed to the employer for purposes of harassment protection at the stage of the case that it was going through was that it was constant, and it wasn't a couple of times. This was something that was just ongoing. It was part of the organizational culture that this was going on, and it was in plain view with the supervisors. So there was something linking it to not just the line employees, but to the organization as a whole. And as we're talking about these things that are really negative and where we wish protections were stronger, I think it's important not to lose sight of the fact that that's not what every employer does or what every coworker does.
Yeah, so just an example, while those experiences are hard to hear, I just want to offer some hope that other experiences are possible. I think about my own employment journey, and probably like for a lot of you, it's been rocky at times. But I was lucky in that one of my very first paid employment was working at a Girl Scout camp in Bartlesville, Oklahoma. And at that point, I had very, very noticeable symptoms: loud, full body motor and vocal tics, and coprolalia. And I was working at a camp in the buckle of the Bible Belt. And you wouldn't think that would work, but it did work. Part of the reason it worked is because most of my experience with youth prior to that time was with the Girl Scouts. I was a lifelong Girl Scout. So we shared the same vision and values. And I was able to work my way up through 7 summers from counselor through assistant director. And then later on, when I got my master's degree and was looking for employment, I was able to work for a couple of years for the Girl Scouts, working with underserved girls, doing Title I work, working with Hmong and Latina girls, and working with the deaf community. And that led to other career advancement throughout my life. So I guess I just want to make 2 points. You can have some supportive work environments when you let them know what's going on. And also those early experiences really can build on a successful career.
And one of the hopes and goals of a successful career is that, you know, when you start with one particular position, hopefully that leads into a career path where there might be a promotion over time or changes in job responsibilities. But with changes in job responsibilities, also can come changes with accommodation needs. So it's important that we view the accommodation process not just as a one-time thing that you do early on, or when before you start, or just when you're starting, but throughout the career with an organization, or throughout the career over a number of organizations, as responsibilities change, or as symptoms change, or as different needs arise. So just making sure that, if there's, for example, that distinction between working remotely if you're a supervisor, working versus working remotely if you're not a supervisor, you might need to have that conversation again as you go through and climb in your responsibilities. Another very frequent situation that comes with accommodation changes, or that can come with accommodation changes, is if you had a particularly supportive or unsupportive manager, and there's turnover in who your supervisor is or who the HR staff are, because what worked under one manager, a different manager might have a different response to. So one of the things that's really painful to see in terms of what is coming through my door, or what's coming to my desk, is I see a lot of times where people, instead of going through and really formally documenting that an accommodation has been made and put in place, there'll be one-off conversations with no medical records provided, to no letter from a doctor saying that you really need this, and one manager will say, sure, that's fine, and then as soon as they leave and a different manager comes in, things change, and an accommodation that you thought was in place, they have no idea, this new manager has no idea what it is or why you need it. They deny it, they pretend that there weren't those prior conversations. So in anticipation of manager changes or turnover at an organization, it can be really important that some things that are done in an oral format are then documented and followed up in writing. So for example, you are allowed to ask for an accommodation request orally. It doesn't need to be in writing in order to be an accommodation request. You don't even need to use the word accommodation. You can just say, because of my disability, I need this change in how things are carried out. And that's an accommodation request, even if it's not in writing and even if it doesn't use the magic word accommodation. But if there's going to be potentially a change in management or a change in who owns the company, things like that, it can be really helpful to follow up those oral conversations with a quick written email summarizing the content of the conversation and accompanied by a letter from your doctor showing that the accommodation is needed, because that's going to back up that it and show that, enable you to prove it in case something goes wrong. Which kind of gets into the final point, is if something does go wrong, what are your options? So again, we talked about 3 general categories of discrimination at the outset: a refusal to accommodate, disparate treatment, which is where you're singled out to be treated differently than somebody else, and disparate impact, which is a general policy that is excluding a certain group of people. So all three of those are able to, you're able to have complaints related to those areas through the Equal Employment Opportunity Commission, which is the federal agency that investigates and adjudicates at the initial stage the claims of discrimination. And in general, you can still, if you can have a claim even if you're still at the employer. If you are still there, my recommendation, for example, if it was a refusal to accommodate rather than, or a harassment claim rather than a termination claim. If you're still there, my recommendation as a first step, if you have some time before the filing deadline ends, it would be escalate the matter internally. If your individual supervisor is not responsive to it, go to their supervisor or to HR to try to see if there's something that can resolve the situation short of a formal filing, because oftentimes as soon as there's a filing with a federal agency, employers can become very defensive. And it's helpful if they're thinking about things in a problem-solving mindset rather than this kind of defensive mindset. And the other thing that I would recommend doing before filing a complaint is to gather documentation. So in Wisconsin, there's a statute that allows employees to access their personnel records. So you could request that. There might be similar laws in other states, but in general, employers may be willing to send you a copy of their personnel file, even if there's not a statute requiring it. And if there's other documentation, just make sure to gather that, and so that you have the evidence to prove what happened. Or if there's witnesses, and make a list of the witnesses, make a timeline of events that happened, so that you're organized and can convey the situation in the complaint form. The other thing that I want you to know about the complaint process, one of the other things is, oftentimes people are worried about, if I file this complaint, then it's going to get worse, or if someone helps me as a witness, they're going to get fired too. And retaliation based on participation in the complaint process or opposition to discrimination is itself against the law. So there are some protections against retaliation as well. And one of the other pieces to know about the complaint process is, you should, if there's something that you fear might happen but that hasn't actually happened yet, the complaint isn't going to be effective until after that adverse action has already occurred. Now, if there's some reason to fear it, maybe what generated that concern might itself be an adverse action, but something like demotion, you can't say, oh, I think I'm going to be demoted. It's got to be after the actual event has occurred. And there's filing deadlines in states that also have a state equivalent. The filing deadline is going to be 300 days. So in Wisconsin, it's 300 days. If you're in a state other than, for private employers, if you're a state other than Wisconsin, you should seek advice from a lawyer who's licensed in that jurisdiction about the deadline. If a state does not have state protections that are equivalent to the federal protections, the deadline's going to be shorter. It's going to be 180 days for private employers. And then there's a much shorter deadline if you're employed with a federal agency. It's going to be 45 days. If it's a state agency, then the 180 days or 308 days should apply, but you should talk with someone who's licensed in your jurisdiction. So those are very strict deadlines. You should make sure to file before the deadlines expire, or else you could lose important rights. And the deadlines are going to be counted based on the first thing that you're alleging is discriminatory, not just the most recent thing. So there's that piece. There are situations where there's a state agency that protects rights similarly to the federal agency. If there is a state agency in your state, in Wisconsin, it's the Equal Rights Division of the Department of Workforce Development. then you can pick which you file with, whether you file with the federal EEOC or the state agency. And in most cases, including Wisconsin, the state agency is going to cross-file it, send it to the EEOC, or the EEOC, if you file with the EEOC first, would cross-file it by sending it to the state agency. So if you file with one, generally they're going to send it to the other, but the one you file with first is the one that is going to do the investigation, and they'll be looking at either the federal law for the EEOC or the state law for your state agency first. So you should talk with an attorney in your jurisdiction about whether there's differences in the federal law versus state law, and if one creates advantages for you that the other doesn't, or disadvantages. So I think those are
Sure. So we're just going to hit a few resources here. I won't go over these in detail because we want to leave some time for questions. If you get this as a PowerPoint, these will be clickable links, so you can find the web access, and you can follow up with Amethyst if you're interested in that. The first is some links to the EEOC. Second is the Job Accommodation Networks, which we mentioned earlier in the presentation. The U.S. Justice Department, Civil Rights Division, ADA website, and some resources from Disability Rights Iowa. Finally, Protection and Advocacy Network, that's the agency. Disability Rights Wisconsin is the agency that Steven both work for in our state. Your state or territory has a Protection and Advocacy Network, and you can access free legal services there around a variety of disability rights issues, not just the ADA, so it's good to know about. Independent living programs are programs that are run by people with disabilities for people with disabilities. So that's an important resource. Again, there should be one in your state, and those services are free, especially for young adults. One of the things we wanted to hit, that when you're a young adult, it's really helpful to think through ahead of time disclosure and how that will work as you start your whole working career. So a couple of resources we wanted to highlight there. The Up to Me Teen program talks generally about disclosures. And then the 411 on disability disclosures is a very comprehensive workbook that focuses mainly on disclosure in the work and post-secondary education realm. So that's all we have, and we'll open it up for questions now.
Okay, the first question comes from Greg M, and it lists, as someone in the job market now, I have noticed nearly all of the online applications ask if I have a disability, and they list many different types. I have the option of yes or no, or I prefer not to answer. And then he provides the link to the dol.gov site, and it lists the regulation 503, section 503.
So I take that the question then is whether that's allowed or why they're doing that?
Yes.
Yeah. So one of the exceptions to the limitation on what employers are allowed to ask is that they're allowed to gather information about for voluntary affirmative action programs. So if they want to make sure, for example, that they are recruiting and promoting the job description from sources that attract people with disabilities or certain other groups, they're able to ask and some information about the candidate pool in order to assess whether they're accomplishing that goal. Those forms should be voluntary. The one thing that they can ask that touches on whether you have a disability that wouldn't necessarily be voluntary is whether you can perform the job with or without accommodation. But it's not, they have to phrase it in a way where you're not disclosing whether you would need an accommodation if it's a mandatory question, but just whether you can perform the job with or without. And so it sounds like the particular form that you're talking about was probably for a voluntary affirmative action program, or those particular forms generally are. The other thing that is unique to the ADA compared to many other civil rights laws is that many civil rights laws prohibit making a distinction among classes of employees. So for example, if you're looking at race or gender, and an employer cannot make make a distinction in general. But with the ADA, the prohibition is against discriminating against people with disabilities rather than making a distinction. And so where that matters is that unlike other areas of protected classes, employers actually are allowed to favor applicants with disabilities where they couldn't make that kind of favorable action in another circumstance. So employers might ask for voluntary disclosure about disability in order to see whether someone qualifies for some kind of voluntary program that they're giving. There's a program under that most federal positions have. I'm thinking it's called Schedule A hiring, but that's what the type of thing where those disclosures might come in place.
Okay, and the next question comes from Eric G. And he writes, our office is moving to an open cubicle workspace. I have informed HR. They said that they will give me an office, but are concerned about how to communicate this to the rest of the staff. There will be a few offices available, but these are reserved for directors. What are your thoughts?
Well, I'll take it from a legal perspective, and then I'll let Ellie respond from the practical perspective. From the legal perspective, the accommodation request is a confidential process. So you're allowed to disclose if you would like to, but the employer could not require you to disclose that was the reason why you are in that placement. And it can be tricky to explain something that other employees don't understand, but they can't require you to disclose that.
And I think from the practical perspective, this is a good time to assess how comfortable you are disclosing that you have Tourette, how much you would like your coworkers to know about it. If you're comfortable and they're aware, you might, just say, hey man, look, I've got some vocal symptoms that are problematic to me. Nobody really wants to deal with that, so I'm going to have my door shut. If you're not as open with your colleagues about your diagnosis, that's a good time to really think about how you're going to want to say something. I personally would probably get ahead of the story just because I wouldn't want others to feel like I had an unfair favoritism. So think through a way to say that you might not even disclose you have any disability of any kind. You could just leave it as simply as, well, I just need this office and don't want to get into why, and then be willing to change the subject. But I think really some thought ahead of time on how open you want to be, and is this a choice point where you want to change what you disclose to your colleagues. And again, the Up to Me resource might be a good one to take a look at, even for adults, on how to think through the pros and cons of disclosure.
Okay, and the next question comes from Susan B. And she writes, my son is working with a vocational program to find a job. Most companies are telling him that they will not allow a job coach. Is this legal?
So I would think in most situations, a job coach would not be that, it would not rise to the level of creating the type of imposition that would be an exception. If there's space for another person to stand there or be there, that I could see space constraints potentially, depending on the nature of the work, potentially impacting whether something's reasonable. And the employers might raise concerns about confidentiality, but there's ways to work around that. So in general, I would say, the analysis about what's reasonable is going to be issue by issue. I don't know whether there's particular cases that have squarely addressed the issue of job coaches, and so that would influence the analysis. But as a general rule, it would think through, well, what are the consequences of having the coach there? for the business. Is there some added expense? What is the added expense? What, is that, who's paying for it? So if it's something where a state division of vocational rehabilitation is paying for the job coach, that's very different than asking the employer to pay for the job coach. If asking the employer to pay for the job coach, that's likely to get into a type of expense where it would be an undue hardship on the employer. But if it's being paid for by vocational rehab, the vocational rehab service, and there's not really something else that is creating either a financial hardship or a threat to health or safety, then and that rises to the level of being quite serious, then I'm not sure that I would see just a blanket rejection of job coaching as a type of accommodation that would be available. I would, since you're talking about a specific circumstance, and the laws do vary state by state, and I don't have the level of detail to give you advice about your specific circumstance, I would recommend consulting with a local attorney who's licensed in your state. But these are some general principles that you might use to inform your questions to that attorney.
Okay, well, thank you everyone for joining us today. I realize I didn't mention this in the beginning, but TAA stands for the Tourette Association of America, in case those of you that are joining us for the first time. And we are working to better the lives of individuals with Tourette syndrome and tic disorder by raising awareness, providing education, and advancing research. We currently have 31 chapters, 80 support groups, and we also have a medical support network of centers of excellence that are throughout the United States. If you have any more questions, please feel free to visit our website, tourette.org. That's TOURETTE.org, or email me, Amethyst Johnson, at support@tourette.org. Okay, everyone, have a very good afternoon and a nice weekend.